Hello, this is Matt on the Moon Lambeau channel. The SEC is in panic mode as they continue to try to hide evidence that, frankly, may destroy their entire lawsuit against Ripple. And so there are a couple legal filings today that actually maybe didn't get as much attention as they otherwise would have if not for the fact that crypto markets collapsed in terms of price action and have been rebounding ever since. But these are some interesting legal filings here. And so Ripple is effectively demanding that this evidence end up seeing the light of day. And so what am I talking about? Well, there were two filings here. The first one had to do with the production of video and audio recordings at Ripple staff meetings. And the second one, which is the one that I was more interested in, I think most people would be too, was this one having to do with were SEC employees allowed to purchase, buy, sell, hold XRP, and if so, during what time periods and why? A lot of implications there because, as you probably well understand at this point, Ripple has what is known as its fair notice defense, which is this idea that, hey, we've been acting in broad daylight with our operations for the better part of a decade, and there was no sort of indication that what we were doing, we Ripple, in the way that we were selling XRP, an asset that we own, there's no indication from the SEC that that would have been illegal. And so, if anything, the SEC, pretty damn clear to me, they've been contributing to market confusion here. And so, if SEC employees are purchasing XRP, what's that say about the certainty surrounding XRP's legal status? But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos, but it's purely as a hobby, just for fun. And so, big thanks to James K. Filan on Twitter here. He's an attorney within the XRP community, so he doesn't work at Ripple, he's not part of the SEC, and he regularly shares the latest documents surrounding the SEC versus Ripple case. And these actually have only been out for several hours or so at this point anyway. But this first one I can be really brief with. It's 3 pages, but I'm actually not even going to read any excerpts, I don't think. Here's what James Filan wrote about this. He wrote, Ripple files motion to seal certain exhibits and transcript excerpts filed by the parties in connection with the SEC's motion to compel production of video and audio recordings of Ripple staff meetings. And so we recently found out that Ripple had been recording video and audio of certain staff meetings. And the reason is pretty simple. David Schwartz actually explained this on Twitter. He's like, well, we've got employees all over the world, and unless you're going to make somebody attend like a meeting at what would their time locally be like 3 a.m., it's best to just record, and then when it's during regular business hours for them, they can go ahead and check out the video or audio recording. So it makes sense. But the SEC just recently found out this was the case after having a former Ripple employee speak under oath during the deposition. And so once they figured that out, they're like, okay, well, we didn't know that existed, and so now they're trying to go to Ripple and get all this video and audio. And Ripple is basically saying here, hey, there's certain parts of this that are sensitive, personal employee information, this or that, and so they're just trying to make sure that that type of private information doesn't get out. And really, I don't know what the hell the SEC thinks they're going to learn from this anyway, because what's relevant ultimately in this case, as the court has made very clear, is objectively whether Ripple did or did not do something wrong. Like, even if executives at Ripple thought that selling XRP was wrong, and they don't, I mean, that's pretty damn clear, but even if they did, that's their subjective opinion. The court's made pretty damn clear what actually matters is objectively, was it right or wrong according to law, basically. And so then there was this one, and this is the real interesting one, I think, anyway. So here's what James K. Filan wrote. Ripple files reply in further support of its motion to compel the SEC to produce documents showing whether SEC employees were permitted to trade XRP and other digital assets. And so I made a video where I pretty thoroughly covered what the SEC had to say on this topic. And I pointed out all the areas where just, me as a layperson, not having a legal background, is like, that doesn't make sense, that doesn't make sense, that's hypocritical. And so I was really looking forward to Ripple's response here. and they did not disappoint. So let's jump in, and I actually did print this thing up. It's not that long anyway, just a few pages, but I highlighted the parts that I wanted to share here. And so it begins as follows. Dear Judge Netburn, defendants Ripple Labs Inc., Bradley Garlinghouse, and Christian A. Larson, together the defendants, respectfully submit this letter in further support of their motion to compel the SEC's production of aggregated and anonymized information relating to trading pre-clearance decisions as to XRP, Bitcoin, and Ether. The SEC's opposition letter filed on September 3rd, 2021, ignores or misstates key issues relevant to the court's consideration of the motion, necessitating a brief response. Yeah, no kidding. They definitely ignored and misstated all sorts of things, and I highlighted them in my video where I was talking about it just a few days ago. And so check this out. Ripple's attorneys write the following. First, the SEC's claim that the motion constitutes an intrusion of privacy for SEC employees ignores that defendants do not seek any particularized information relating to SEC employees. Defendants seek production only of aggregate, completely anonymized information of a narrow scope and for a limited period of time. There is no Privacy Act obstacle to the court ordering production of this information. Yeah, so I talked about this in the last video. I was like, this is the most absurd thing. I don't know how anybody, especially a judge, is going to think that this makes any sense, because they were saying, yes, he was actually arguing that it would be an invasion of privacy if anonymous data about people were released. And I'm sitting like, how is that? How is your brain? Is your brain broken? How is your brain coming to the conclusion that information that doesn't provide, like, isn't private by nature because it's literally anonymous? How is that invading somebody's privacy or anything of the sort? And of course, anybody, you don't need a sort of legal background to understand this. If you have half of a brain, at least, you will be able to tell that anonymous information about humans is not going to invade their privacy. And they did not articulate a reason as to why it did. They just said they literally said this, even aggregated information, the SEC argued, would be an intrusion. That's what they said. That makes no damn sense at all. And so here you have Ripple, thankfully, calling them out and saying, no, it doesn't make sense. We're just asking for anonymous information on the aggregate. And then they wrote also the following. Second, the SEC's opposition letter makes no attempt to substantiate their passing claim of burden of production. So I'll pause right here. But the SEC is trying to claim that if they were forced to get all of this information about whether or not their employees, the SEC employees, were buying, selling, holding XRP, Bitcoin, Ether, if they were forced to do it, it would just be too burdensome. To have to produce all this information, it could take a crazy amount of time. That's what they were saying right there. Anyway, Ripple's attorneys continue now. There is no basis to believe that the information sought, which would be records of pre-clearances that should be kept in the normal course and presumably are not extensive, is burdensome. There's no way it's burdensome, of course. Indeed, our understanding is that these records for XRP span only a little more than a year. During a meet and confer, SEC counsel orally indicated that SEC employees could not trade XRP after the formal order of investigation was issued as to Ripple on March 9th, 2019. That counsel was able to make this oral representation. The fact that you could do it strongly suggests that the SEC has already done the work on this issue, thereby undermining its burden objection. How about that? Yeah, exactly. How would they know specifically all of that if they'd not already done the work? How about that? And then they're claiming that would be a burden to them. They're just arguing whatever. They're seeing whatever sticks. And then they write here, yet the SEC refuses to confirm its oral statement in writing or in any usable evidentiary form, and it refuses to state how many SEC employees requested and or received permission to trade XRP after January 2018, and when pre-clearance was first required, but before March 9th, 2019. And so and it's obvious, if there were employees, especially during that time period, purchasing XRP, that's a serious problem for the SEC. Which is why they'd be panicking over all of this. This is another thing that would just go a long way to destroying the SEC lawsuit against Ripple. And then they wrote the following. This I love. This is awesome. Evidence that the SEC permitted XRP purchases and sales by its own employees without any restriction until January 2018, as the SEC concedes, and likely through pre-clearances from January 2018 through at least March 2019, which the SEC refuses to confirm, directly undermines the SEC's claims that since 2013, individual defendants acted recklessly with respect to Ripple's XRP sales because it was so obvious that XRP was a security, such that they must have been aware of it, and Ripple had fair notice that selling XRP was a Section 5 violation, and also that XRP was an investment contract under Howey. So it goes a long way, as they state right there, to destroying all of those claims, which is why this is such a big freaking deal. And what do you think is likely? I'm willing to speculate at least a little bit on this. I think that SEC employees have held XRP. I mean, there's so many of these employees. There are probably some that have held XRP and all sorts of other cryptocurrencies. And this is inconvenient. This is going to be very inconvenient for the SEC, especially if it was brought to their attention and they gave it the green light and approved it. Because why would that happen if it's the case that XRP is just an unregistered security of Ripple Labs? How could that be the case? Which is why this is so rich. I'm really looking forward to seeing how this unfolds, but I don't think it's going to be good for the SEC, to be honest with you here. So I'll go ahead and wrap up there. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.